thinking of going, I wouldn't even hesitate for a moment.
They're settled.
Yeah.
I wrote them a check yesterday.
You'll love it.
You can go in our Kia for $400 return to Israel from anywhere in Europe.
My guy leaves today at 4 o'clock to Malaysia.
I didn't know that.
Now who doesn't know what's going on?
I did not know.
Hey, I got a check last night for 10 grand.
I told him not to go more than 25 minutes.
Good morning. We've got a very full day, so we're going to start pretty well on time. My name is Helen Bernstein. I'm Counsel Program Development at the Law Society. Welcome to our 4th Annual Employment Law Forum. Just a couple of announcements. Please take some time to fill in the grade course evaluation form that's in your binder. To increase access to CLE across the province, we are videotaping the program. We want to thank our chairs, Howard Levitt and Barry Kuretzky, both prominent members of the Employment Bar, and the entire faculty for all their help in putting the program together. I know you're in for a very interesting day, and I'll turn it over to Howard. Thank you.
Well, good morning, everyone, and welcome to a day that I promise to be at least interesting, and if it isn't, feel free to jeer and heckle and otherwise express your displeasure. We think we've come close, other than, of course, the chairs, to perfecting our speakers this year after 3 tries before now. Now, we've chosen today to go through the course of the action from pleadings through discovery, through mediation, onward. And if you stay to the very end with the judges panel and the senior practitioners panel, you'll have all of the strategies necessary to win. It's sort of interesting what's happened to the law in the last few years. It seems to be characterized by nothing other than uncertainty. How much notice do you get? Well, it depends how well you treat someone. Is there cause? Well, it sort of depends on the context. Is there a constructive dismissal? Well, does MISUD apply? It seems the law is increasingly devoid of law and increasingly filled with strategy, and that, more than anything, appears to dictate what's going to happen at the end of the day. So we've attempted to put together a group of strategists from beginning to end to give you a pretty good sense of what the possibilities are in winning successfully on either side a wrongful dismissal case. I had my first case with His Honor, Justice Echlin, just last week, and I must admit to some degree of initial trepidation. After all, after viewing him as my main competitor for a number of years, all of a sudden he has a chance to kick me around, and kick me around he did for a while. And at the end of the day, he produced a judgment which I've said before today, and not to him, was Solomonic. Randy was always a strategic settler, and it's very interesting that that was reflected even in his judgment. His Honor managed to put together a judgment which Gary Caplan, who was on the other side, just told me the clients settled themselves yesterday because of the various incentives he put in place that made going ahead, if at all, well, it put in all the right incentives for both parties. So his approach to litigation seems to be his approach to writing judgments. I'll turn it over to Barry.
Thanks very much, Howie. And getting kicked around in court, I can understand that. That's what Mr. Justice Gans used to say about you last year. Anyways, I want to thank everybody for coming.
But with him, I clearly won.
Yeah, absolutely. I want to thank everybody for coming. And as we all know, we're involved in an incredible area of law. The variety is endless. I often say to clients, you know, if this was a law school exam, nobody would believe the fact pattern. You'd think the prof was smoking something. And to prove the point of just how there's just no end of the variety in this area of law, I happened doing nothing better one day to reading Forbes magazine, the 50 best rated business schools, looking at a new career potentially, and came across an article called Transsexuals and the Law. Are people who change their gender entitled to the protection of anti-discrimination laws? And just so that we think, if we ever think that we've sort of seen all the fact patterns, we haven't. The article is somewhat interesting because it tells us that a Nexus search turns up 625 news stories worldwide dealing with discrimination in the proximity of transsexuals. The cases tend to start out as exercises in employment law and end up in the metaphysical never land. So when we first started with Randy practicing in this area of the law, and Howie some 25, 26 years ago, we were talking about reasonable notice. The law expands and continues to expand, and I think we'll all enjoy it, hopefully, for another 25 years. I know that looking at my debt rate, at least I need to do this for another 25 years. It is an incredible pleasure I have today to introduce my close friend and colleague, Mr. Justice Echlin. He was originally going to be on the senior practitioners panel. Unfortunately for him, a change in salary puts him into the keynote address. Randy's been on our senior practitioner panel a number of times, and hopefully for those of you who have attended in the past, you will have made very careful notes, and they may be helpful when you appear before him in court. You'll remember, Mr. Justice Echlin, 4 years ago on the senior practitioners panel, you suggested this particular idea. If you take careful notes, it will work. Next year, we'll have Randy back to be on the judges panel. Correct, Randy? Absolutely. And I think Randy's contribution to the employment bar is legendary. He was an editor, and until he, are you still an editor on Canadian cases of employment law? Still continues to be an editor on Canadian cases on employment law, is the author of seven serious books in terms of the area of the law. He has made a vast contribution to all the associates and juniors he's helped mentor along the way, and he has been, in terms of my practice, invaluable as a resource and someone I could always take a difficult file to and get some creative and useful ideas to move forward. It's with the greatest pleasure that I introduce Mr. Justice Echlin today, who is going to give us some serious and practical advice which I know will be unbelievably useful in your personal practices. Randy?
Well, thank you very much, Howard and Barry. You're to be commended for this, the 4th annual Law Society Employment Law Forum. I'm honored to have been invited to join you this morning, and I can tell all of you that you're very fortunate in Ontario, which is not the case in a lot of jurisdictions, to have a very sophisticated and high-level CLE program through the Law Society of Upper Canada. It's the efforts of the co-chairs, Messrs. Kuretzky and Levitt, and all of the practitioners and judges who freely give their time that makes this a very strong bar in Ontario. And I can tell you, it isn't the case in a lot of the other provinces and in a lot of parts of the United States. We have a very affordable program that's comprehensive, and it's all here for the taking. So let me as well, I guess, congratulate my new brother, the Honorable Justice John Sproat, who in the early days of the planning of this year's symposium was slated to be a member of the Senior Employment Law Practitioners Panel as well. John will be a valuable addition to the Superior Court bench in Brampton. And I guess I should also note that just recently, Charles Hackland from Ottawa joined our bench. For you Torontonians who are not familiar with Charles, he was the counsel for Cognos in the famous Queen and Cognos case. The employment law bar and the prowess of our trial bench in this area has been augmented by their appointments, no question. This address is entitled Reflections on a Career at the Employment Law Bar. It sounds kind of like a funeral eulogy, but let me start by taking it back to the year 1975. I was then a lowly articling student at McCarthy & McCarthy, as it then was. The Employment Standards Act had just been passed. George Finlayson, as he then was the head of the litigation department, which featured such luminaries as John J. Robinette, Douglas K. Laidlaw, and a host of young pup lawyers like Alan Lenzner, Tom Heitzman, Ron Slatt. Well, Mr. Finlayson asked me to assist him in the preparation of his 1975 Law Society of Upper Canada Special Lecture on Employment Law that year. And you can check that out by going to the special lectures of 75. And in those years, David Harris had just graduated and had yet to publish his landmark text. Brian Grossman was still practicing law in Saskatchewan. Howard Levitt and Barry Kuretzky were still in law school. and there were no CCELs. If you wanted to research employment law, you had to look under master and servant law. It had been 15 years since the late Chief Justice McCruer had quashed the unspoken 6-month maximum notice period in Bardol and the Globe and Mail, and that was a case upon which Ian Scott had juniored to Andy Bruin. And the law was pretty static in this area. There was no well-defined bar. Most general practitioners and litigators tried wrongful dismissal actions. Well, Canada has enjoyed untold kind of post-war prosperity during the 50s and 60s and 70s, and it wasn't until the early 80s that Canada learned what a recession was all about. Thereafter, we seemed to experience a recession at the beginning of every decade, the early 80s, the early 90s, the early 2000s, and that, of course, created much work for employment law lawyers. During my years of practice, 1977 until this year, which were all at Borden Ladner Gervais, I found that aside from assessing the applicable periods of reasonable notice, the primary issues were, and probably still are, aside from Barry's creative transsexual stuff, either just cause or constructive dismissal. Now, during my years at the bar, I intentionally kept my practice to a 50-50 mix between plaintiff and defense work. And I felt that that gave me a perspective and a balance that I might not have otherwise had. And I encourage all young lawyers to take on both types of briefs. By doing a plaintiff's case, you'll learn firsthand what makes an individual tick. It's hard work, but it's very rewarding. Doing defense work teaches you to appreciate corporate concerns, and the insights you gain from one side of the fence will inure to your benefit and to those of your client the next time you face an opposing plaintiff or an opposing employer. What did I learn during the past 26 years in my involvement in several thousand dismissals? Well, let me share with you my top 10 list. Number 10, when acting for a plaintiff, there's always an element of grief resolution involved. During the first few interviews, which are often within 24 hours of the dismissal, take the time to let the plaintiff ventilate. The loss of a job is right up there on the stress scales with the loss of a parent, child, or spouse. Take time to listen to what they really want. Invite them to bring their spouse or partner. There's an old saying that the termination bullet goes through the dismissee and lodges in the spouse. The husband or the wife are an important part of the equation. They've done my guy or gal wrong. In many cases, they are the important part of the decision-making process when it gets down to settlement. Number 9, practical tip. Don't be afraid to ask plaintiffs for an initial retainer during the first phone call. If you're going to do plaintiff's work, you have to make the lawsuit theirs. If the individual is reluctant to pony up and even an initial retainer, then you can expect that you're going to have an even greater problem with your final account. If the client understands that your time is valuable, they'll be more respectful about how they use it. Dismissed employees, as you all know, have plenty of time in their hands and only one thing on their minds, their lawsuit. In this way, these actions are a lot like matrimonial matters. If they're not managed properly, they can get out of hand. And in saying that, I have to admit that I've made a few exceptions over the years where I felt there was no need to request money or the client was unable to afford me and the case was meritorious. I guess in the end, use your best judgment. Number 8, be a compulsive list maker and letter writer. Keep the ball rolling. A happy client is one who feels that you're vigorously advancing their interests. They won't feel that way if you don't let them know what you're doing. Dictate the initial demand letter during your first meeting with your new plaintiff client right in front of you. Write the initial reporting letter to your employer client immediately after your first meeting. They'll be impressed that you're a lawyer of action. You have to do it anyway, so why not deal with it up front and instead of leaving it to be added to your to-do list? If acting for an employer, send regular reporting letters. The head of HR to whom you're reporting is accountable internally, and your job is to make that person look good. Plaintiffs and corporations are funny. Neither of them like surprises. Number 7, learn to say no. Don't build unrealistic expectations in your clients. While it may seem like an appealing prospect at the outset to promise the world, it becomes extremely problematic as matters proceed and your case doesn't work out nearly as well as you had initially promised. As well, don't be afraid to turn some clients away at the outset. If you sense that their expectations are unrealistic or that they want you to do something that runs against your grain, invite the client to get a second or third opinion. You'll be thankful that you did. Similarly, if you think that you're not on the same wavelength as your client as the matter proceeds, don't be afraid to fire a few clients every year. There's an old saying that 95% of the stress in practice is caused by 5% of the clients. That's true. So such a move may be in your best interests and those of your client. Number 6, be aware of mitigation. This is the wild card in employment law. Even though the case may be initially worth 18 to 24 months, in most cases, the dismissed employee will become reemployed or self-employed within 6 to 9 months or less. Mitigation is the employer's best friend. It also dramatically changes the complexion of an initially strong plaintiff's case. Number 5, if a reasonable settlement offer is made, take it and run. This applies to both plaintiffs and defendants. Don't spend 2 years fighting over the difference of a month or so. By the time you're through, the additional costs will have outstripped the difference in issue. Number 4, return phone calls and emails same day, next day, if not immediately. It's particularly important in employment law. I've encountered cases when I was in practice where I returned a call within 15 to 20 minutes and the prospective employer or employee client had already moved on to find another lawyer. Both employers and dismissees are under high stress and they want their matter dealt with right away. These people are used to 1-hour photo stores, same-day dry cleaners. You're no different. Remember, you're not the only employment lawyer out there. So set up an appointment immediately. Let them know that you mean business. I encourage you to answer your own phone calls and return calls on the evenings and on weekends. It truly impresses clients and prospective clients, and it shows that you care. It also helps justify the high hourly rate that the profession commands, too. Number 3, act professionally. Be courteous but firm with opposing counsel. Grant indulgences if they don't compromise your client's interests. Being unduly aggressive will shorten your lifespan and will potentially disadvantage your client. Get along by getting along. You'll be amazed at how an ounce of courtesy will turn into a pound of cooperation. It will undoubtedly help you achieve better results. Number 2, consider ADR. There is no area of the law that's more suited to alternate dispute resolution than employment law. This is something that Barry Fisher realized many years ago when he gave up his thriving employment law practice to become a full-time mediator arbitrator. There are very few dismissal cases that can't be arbitrated or mediated cheaper, faster, and more successfully than standard litigation. And it was for that reason that when compulsory mediation was first introduced into Toronto, it was first tried on all wrongful dismissal cases. Be careful, though. It shouldn't happen too soon. The parties have to be ready for it. Dispute resolution is akin to grief resolution. There must be some anger, some denial, some negotiation. Those steps have to be completed before the resolution occurs. But when the time's right, I strongly suggest that you recommend it to your clients. Number 1, finally, enjoy your practice. You've all been truly blessed. You have a chance to make a difference in people's lives. You all make a very good living, and at the same time, I encourage you to do some pro bono cases. Don't let the occasional case or an individual can't afford to pay to get in the way. Some of the most satisfying cases I handled over the 26 years didn't involve settlements in the millions of dollars. Part of enjoying your practice is the lifelong friendships and relationships that you'll make within the employment law bar. The employment law bar in Ontario is very collegial. As you practice, you'll come up against the same people on a regular basis. You'll follow their lives and careers. You'll see their families grow as they develop. You'll get to know your opponents, and you and they will develop a level of trust in each other. You'll find that they'll come to rely upon your word. If you develop a reliable reputation with the opposition, you'll find that you close more deals faster and in a more advantageous fashion. And if you develop a reputation as a deal closer amongst your clients, you'll be amazed at the wonders it does for your business development abilities and reputation. As you might imagine, I felt tremendously blessed to have had the opportunity to be part of a truly enjoyable and fulfilling practice over the last 26 years. This room, I can tell you, and those viewing us from afar, is full of highly talented and creative counsel. It'll be my pleasure and honor to receive submissions from you in the years to come. Thank you.
Randy, take some questions.
Sure, if you like.
If there's any questions, we have some time. So just, yes.
Well,
We might want to repeat what the question is.
Sure.
The question was, Randy made the point, Justice Echlin made the point that you have to relearn everything. That settle when it's appropriate to settle from a timing standpoint. And the questioner said, in the advent of early mandatory mediation, sometimes the parties just aren't ready to settle.
yeah. I think you've got a good point there. Whether a party is ready to settle or not really depends on the party. Some people are fast learners, some are veterans. Companies, for example, are used to dealing with employment law cases, so they're ready to settle whenever. They've also got their experience background behind them as well. But I tend to agree with you that in a lot of cases, the parties aren't ready at an early stage, but there's nothing to stop you, frankly, from having a second mediation when you think it's right. And using the first mediation for the purposes of trying to simplify the issues. You know, if there's 32 grounds of cause, maybe you can get rid of half a dozen or 2 dozen of them at that mediation and start to focus in just on the nub issues. I think there are lots of parties for whom who are ready for mediation at the early stage. There are lots that aren't. And it's your judgment as counsel to decide whether your client's ready or not. And if they're not, then I would certainly, if I had a case against Howard or Barry, and I had a plaintiff client who I think needed a bit more time to digest and accept the facts as they've come along, I tell them that. I call them up in advance and I say, look, my client's not really ready to cut a deal right now. Let's talk about some of the issues. What use can we make of this? And let's agree to meet around the corner 6 months from now or 12 months from now when they're ready, or I'll call you when I sense my client's ready to settle.
Yes.
What about in a situation where the employer's counsel says, why don't you wait till we hear about events for the time being, let's go right into mediation. So in other words, do it more expedited, where the parties are ready. What do you think about that?
You'll find a lot of mediators will want at least the pleadings to be the framework for the mediation. But yeah, I've gone to mediations when I was practicing without pleadings. And in fact, I came to almost to the verge of having one before the famous mediator Barry Kuretzky, before the person was fired. My client knew they were going to get fired. The employer knew that we knew. And I suggested to the company's counsel, let's go and see Kuretzky and see if we can mediate this before you even give us the package. So yeah, there's no end to the creativity you can bring to it, just your imagination. And the nice thing about civil law, I'm learning on the bench, is that you can do almost anything by consent. Whereas there's not a lot of consent in criminal law, I can tell you. I mean, it's the nature of the beast. And so if you get two reasonable counsel who know what they're doing, they can structure the litigation to meet their client's best interests.
Yes.
I'm wondering if you could advise us about the conflict between the severe restrictions in the Employment Standards Act in terms of length of notice and therefore damages, and the fairly high awards for people with seniority dismissed without cause. How do you reconcile that?
Well, the question was, how do I reconcile the employment standards periods against the common law periods, basically, to summarize it. I don't see the Employment Standards Act periods, which run 1 to 8 weeks plus an additional week for every year, up to 26 if you're 5 years with a $2.5 million payroll. Some of that still sticks. As a limitation, I see the Employment Standards Act as being an act that has a collection of minimums. It's got minimum wage, it's got minimum pregnancy leave, minimum vacation, and minimum severance. And while a lot of employers out there think that they honor the Employment Standards Act, that's the end of the picture, they're misguided. And in fact, when employers call up the ministry, all the ministry tells them is the Employment Standards Act. They don't talk about the common law. So I'm sure many of you have had employer clients call and say, what did I do wrong? I followed the act, I gave them what I wanted, now I'm getting sued. And when you explain to them that it's just a collection of statutory minimums, you're partway there. Now, there is an instance where you can get more under the Employment Standards Act than you can get from the common law. And that's in a case where you mitigate quickly and the person has a statutory right to, say, up to 26 plus 8, 34 weeks. Common law, you might not get that if the person got a job the next day, but you'll still be entitled to your statutory amounts. So.
When the employee has been forced without independent advice and a bit of threatening to sign one of these agreements limiting him to the Employment Standards Act, he stays 10 years, then they throw this agreement in his face. That's all you got.
Well, the employee either has bargained it away, voluntarily or involuntarily, and if it's involuntarily and you believe that and you think it's challengeable and worth litigating, then you challenge the release and say it wasn't freely given fairly without duress, and you try to get the court to set that aside and provide common law notice.
Randy, I'll come. In practice, I brought very few motions. My sense is that unless it's really crucial and is going to make a huge difference in your lawsuit, I tended to just let them go and we'd carry on and we'd get it sorted out along the way. I've now sat 6 or 7 weeks in weekly court since my appointment, and on average we get probably upwards of about 50 motions a week, which is a lot of work to process. And I'm starting to see all the creative pleadings that are out there. I think you'll find in many cases, if they're struck, leave is always granted to amend. And if you think about the evolution of the common law, the causes of action and the common law is seamless, it's always developing, new causes of actions arise, and I think you'll find the courts are loath to say that some claim could never be brought in some fashion. They may not like the form of the claim, or they may say that it
is inappropriate, but I think we're always open to hear new arguments and new claims, and that's how, 10 years ago there were no Wallace damages. 20 years ago, I don't think there was any, maybe 25 years ago, there was no mental distress damages in this area. They've all evolved. Your practical reply to your question is, unless you think that by bringing a motion you can get rid of the whole action, I'd certainly bring one for a limitation period question. And I think you're all going to find, as of January, that becomes a much bigger issue than it's ever been in employment law. We've always had the 6-year period, and I think the longest I ever had a plaintiff come and see me was 5 years, 11 months. And bingo, I went a statement of claim right away. But now with, generally speaking, the potential of a 2-year period, I think we're going to see a huge proliferation of limitation motions. Beyond that, just because you don't like the poorly drafted pleading, or you think some novel claim isn't something you really want to face, on balance, I'd usually just let it go and deal with it. And if it's really as ridiculous as you think it is, the trial judge is going to have the same view of it too.
Mr. Justice Echlin, dealing with the very difficult client, the high-stress client, that's a very complex area, especially if you're not been at the bar long. What's your best advice on that?
Well, as I said earlier, let them ventilate. I would always spend my first hour interview, when you're meeting them and they're sizing you up and you're sizing them up, my first question would be, tell me what really happened. And then out spews half an hour of, they did this to me and this to me, this to me. And I can tell you a lot of it was irrelevant. I wasn't using it to put my statement of claim together. I was just letting them get it all off their chest. They can't talk to anybody. They've got their spouse, perhaps, maybe a coworker or so, but they got nobody else to tell their story to. And it's part of the cathartic exercise, I think, of grief resolution for them to tell somebody. You don't jump in and say, well, that's a silly thing to complain about. You just listen to them. And then gradually you bring them back by way of questions to what you need to do your statement of claim or your demand letter. And you find they feel so much better when they've gotten it off their chests and they've told you what's on their mind. As far as the high maintenance clients who call you 10 times a day and write you letters and ask for things, interim accounts have a very salutary effect on that. They start to realize that every time they talk to you, it's going to cost them some money. The smarter ones then start contacting your secretary all the time. And you start hearing from your secretary that Mr. Smith or Ms. Jones called 15 times today. But I think, and I was trying to say this in the opening comments, that if you make the lawsuit their lawsuit, you make it a partnership where you're both working together towards a common end, you'll get the desired results. If it becomes adversarial and they sense that they're on your nerves and you're becoming on their nerves, then that's the time to fire the client or suggest they need a second or third opinion and see somebody else because you're just not hitting on the same cylinders together.
And if they're a very difficult high-maintenance client, just remember the last time somebody gave you a really hard time on a file and recommend that they go there.
Your Honor, going back to the last question from the audience, what downside do you think there is, if any, of making a Wallace claim or another perhaps more extravagant new tort claim when there isn't a strong factual foundation? And if you could differentiate that between just in general and what if it's abandoned at trial? Is there still a downside?
Well, there is case law, Howard, as you know, and this is the lob that he's giving me, that if you, for example, allege cause all the way through and then abandon it at the outset of trial, then potentially you can be subjected to further damages as a result of that. I've always been a believer that you go with your strong suit. You don't try to say, as I suggested earlier, I've got 32 grounds of cause. Let's go through them all. Pick the one or two that are real dynamite ones and go for it. Similarly, if you don't have high-handed contumelious behavior that's meriting Wallace damages, don't put it in. Because I'm now finding on the bench that when I look at a trial record before the trial starts, and that's all we get is something like that, I'll look at it and say to myself, well, what's more reasonable, what's more likely to have happened, the plaintiff's side, the defense side, and it's basically just sizing it up. And if you see a lot of extravagant language and extensive use of adjectival modifiers all the way through the pleading, you start to say, well, is this person got the real goods, or are they prone to exaggeration? Whereas if you come in, give it your best shot, tight and sweet and to the point, you start to say, this person's punchy, they've got their act together, they're organized, and, I'm more likely to be persuaded by that side.
Peter, I think you have a question?
Randy, I noticed an alarming increase in the last number of years in the defense counsel simply being mouthpieces for their client or only taking an economic analysis. If I have more bucks, I can drag this out. It's ridiculous position. And I wonder if the bit of conduct you never engaged in is that's different. But can you comment on your perception at the bar and your perception at the bench, if you can? Or does that kind of conduct ever cross the line in terms of conduct unbecoming what, if any, obligation counsel or senior counsel have to a concept of fairness or justice, quite aside from following the instructions of their clients or giving their clients that kind of Machiavellian, kind of advice?
Do the chairs want to summarize that for the tape?
Go ahead.
Okay. The question is, sometimes counsel on the defense side tend to act essentially as mouthpieces for their clients and take positions that are unwarrantedly aggressive and non-settlement oriented, because that may not be in the interest of the administration of justice, but their clients perceive it as in their interest. To what extent does that cross the line, perhaps in terms of the code of professional conduct, perhaps in terms of how a court is going to ultimately perceive the behavior, and what impact might that have on their clients at the end of the day and on the counsel?
I think Peter's raised a very good point. I mean, one of the hottest topics this year is civility at the bar. And I think almost every lawyer in this room has encountered a situation where opposing counsel has been very, very uncivil. And frankly, in the end, that doesn't help either client's respective interests. The lawyers start warring between themselves, and really the battle should be between the clients. How far is too far? When does gray become black or white? It's judgment. And common sense is not that common, I'm finding. I think you have an argument that counsel who, without thinking, just follow their client's instructions are not doing them a service. Certainly, I did a couple of weeks in family law court this summer, and I found, because of the high level of emotions, that counsel tended to do the dictates of their clients a lot more than I saw in the civil practice. And I found through case conferences that the reason for this was if they tried to be conciliatory, they got fired. And, I'd have counsel before me on a case conference, and, I'm the 5th lawyer on this file. I'm the 7th lawyer on this file. And I'd say, well, why don't you talk about this? If we do, we'll get fired. Well, that's not the case in the civil bar, I can tell you. And you have, I think, a duty to your client to act in its best interests. And frankly, if the client isn't buying what you're selling, then maybe you're not on the same page, and maybe you should part company. I know it's easy for a judge who doesn't have to do business development and meet a payroll anymore to say fire clients, but it's true. I resisted, certainly during my practicing years, in just blindly doing whatever the client wanted. And when a client really pushed, and I had corporate clients at a big law firm that I wasn't in a position to fire, I can tell you, because my corporate partners wouldn't be very happy about that. What I would do is have them in for a round table and a strategy session where we talk about the pros and cons of what they're proposing. And I would hope that at the end of an hour or two, they'd come around to the thinking that the downsides outweighed the upsides of doing what they were doing. If I felt that I had a rednecked employment or human resource person who wanted to be a Rambo gunslinger and show those employees that we mean business, and I didn't think it was in the best interest of the company, what I do is bring his boss to the meeting too, or her boss. And saner heads do prevail at some point. But I think you have a responsibility not only to the administration of justice, but to your own clients in the end to act in a civil fashion, to not necessarily play hardball all the time. And there is a place for hardball. You got to know when to hold them and when to fold them. And I understand exactly where Peter's coming from. And again, it's judgment, and that's why your clients pay you the dollars they do, is for your valuable judgment.
Thank you very much, Justice Echlin. I really appreciate that you were able to stay a few minutes and answer questions. I know that's the interactive part of these programs is always very important, and I really appreciate that you took time. I know you're in the midst of a wrongful jury trial. I'm sure it's a great opportunity for you to have some fun, and you'll soon be instructing this jury, no doubt. And actually, let me know when you're doing that charge. But I really want to thank you, and it's greatly appreciated that you took time to be here today.
Well, thank you, Barry, and thank you, Howard.
The next group of speakers is going to deal with the pleadings, current update on the current law, and they're going to do it as an interactive, so they're each going to speak, and then they're each going to challenge each other, so it should be fun. The speakers this morning are my partner, Mr. Vassos, who's over here on the right. You'll see by reviewing George's lengthy bio in the material. George, we've got to get someone to fix this. This is like too small. This is not going to work. George is a graduate 1980 from Queens. He has been involved in conferences. He's been a critical part of my practice, and I really appreciate the assistance he provides me all the time. Lauren Bernardi is called to the bar in 1992. She's the Human Resource Advisor with the Mississauga firm of Bernardi Schultz. She is the author of Recruitment Workbook and DISC, Butterworth 99, and Powerful Employment Policies Canada Law Book. Mr. Nixon here, there's never a joke about Mr. Nixon in his name, unfortunately for Mr. Nixon. Mr. Mulrooney, we did try to get Mr. Mulrooney on the panel today, and John Turner, but they were unavailable. Mr. Nixon, as you all know, I'm sure have litigated with him many times, practices with McCarthy's in 2003. Canadian Lexpert refers to him as the leading lawyer in this area. He has been involved in programs, and I understand from the HRPAO, Rotman School of Management. He has an MBA from the University of Western Ontario, and all those good things. He is a tough opponent. I always remember him showing up. I had a great file with him. He was wise enough to have my client followed from one strip joint to another and was alleging cause when I claimed my client was out working. Let me tell you, when you get some revelations, when Richard calls you up and says, "Barry, you sure you want to proceed with this file?" And we actually went to employment standards, and I think I got some costs out of him, but we did have a good time with it. And although I don't remember my client's wife ever coming to any of the matters. Nancy Sees, as you all know as well, is a superb litigator, well known for her craft with the firm Stockwood Spies. She really needs no introduction in terms of the quality she engenders in terms of the work she does in the courtroom. A very worthy opponent. She's a fellow of the American College of Trial Lawyers, certified specialist in civil litigation, and so I appreciate that these guys are going to work together in a panel here, and hopefully Howie and I think should get out of the way and let them do their craft.
Good morning. I'm going to be kicking off this morning on this particular panel, focusing on pleadings from both sides of the fence. I've always thought there should be a law that if your case makes it to the Supreme Court of Canada in the employment law area, you should get invited to every one of these conferences. Unfortunately, Mr. Wallace is not here with us today, but we obviously continually discuss that case because of its importance and its impact throughout the country. And that's what we're going to kick off today, is with a review on the Wallace case and what you need to do relative to pleading the Wallace case and the cases that have subsequently followed Wallace. Wallace, just to review, was a case in which the majority of the Supreme Court of Canada held that an employer has an obligation of good faith and fair dealing in the manner of dismissal, and that any breach of this duty is compensated by extending the notice period in a wrongful dismissal case. The law, of course, doesn't recognize injured feelings arising from the termination of employment, but where there is bad faith conduct and unfair dealing that has resulted in injuries like humiliation, embarrassment, and damage to one's sense of self-worth, these injuries are worthy of compensation, even if they do not affect the employee's ability to obtain new employment. And in the Wallace case, Mr. Justice Iacobucci did give us some examples of the type of conduct that would merit this Wallace-type extension, including, as we've heard earlier today, false allegations relating to termination for cause and such things as refusing to provide an appropriate letter of reference. There's a recent Court of Appeal case called Gismondi here in Ontario, in which the court clarified and expanded Wallace a bit to say that it's not just the acts of the employer at the very point of dismissal that come under scrutiny. It's also pre-termination conduct and post-termination conduct that can merit some review by the court as part of their overall review process. The Court of Appeal in Gismondi also looked to trying to find a common link or thread from all the cases that have followed Wallace. And the thread that they found is that there has to be something akin to intent, malice, or blatant disregard for the employee. And this, of course, ultimately leads to findings of callous and insensitive treatment, and that's obviously what the court is interested in reviewing at the end of the day. With respect to Wallace and how it dealt with mental distress damages, what the court had to say is that any conduct beyond damages, any conduct giving rise to damages beyond reasonable notice of termination and the failure to provide that reasonable notice must be found on separate, actionable conduct. And those are going to be our bellwether words here this morning in reviewing Wallace. In the absence of such independent, actionable wrong, the foreseeability of mental distress or the fact that the parties contemplated that it might occur is really of no consequence. Subsequently, in another Supreme Court of Canada case, Mr. Justice Iacobucci reviewed Wallace again and told us in that case that the proper threshold for allowing damages for mental distress is a question that has to be determined by a jury or a fact finder, a judge's fact finder, where there's sufficient evidence of that independent, actionable wrong. And that's the key cornerstone. There always has to be sufficient evidence to which one can point to establish that claim. With respect to punitive damages, Wallace addressed that aspect as well, and once again found in order to get into punitive damages, there once again has to be this separate actionable wrong. And without it, we don't get to either the mental distress damages or the punitive damages. In a subsequent Supreme Court of Canada case, McKinley, interesting case in that the court found that there wasn't sufficient evidence in that case to find the separate actionable wrong, but the court did make comments with respect to, on the particular fact pattern in that case, dealing with discrimination and the employer's duty to accommodate disabled employees. The failure to properly accommodate and avoid that discrimination can in turn give rise to a punitive damages award, but always underpinned by this independent actionable wrong. In Prinzo, another recent Court of Appeal case here in Ontario, the court reaffirmed the proposition that punitive damages must serve some rational purpose, and it's only rational if the compensatory damages do not adequately achieve the objectives of retribution, deterrence, or denunciation. And this rationality test, as the Court of Appeal expressed it, applies not only to the question of whether or not to award punitive damages at all, but also applies to the question of the quantum of punitive damages as well. So what exactly is a separate and independent actionable wrong? That's the $64,000 question. We now know from the development of the case law that it would certainly include tort claims, and some of my colleagues will be discussing the tort claims, and that would certainly include, for example, negligent misrepresentations. What hadn't been clear up until a case called Witten was whether an independent actionable wrong could also include a breach of contract claim. Witten was a very interesting case in the insurance context, and in that case, what the court was dealing with was the question of punitive damages in the context of an insurer's duty of good faith and fair dealing under an insurance policy. And Mr. Justice Binney, writing for the court, told us that in the insurance context, a breach of the contractual duty of good faith is independent of and in addition to the breach of contractual duty to pay the insurance loss in the particular case. It constitutes an actionable wrong within the Vorvis rule and does not require an independent tort. So what the Witten case told us at the end of the day was that not only can you look to torts for independent actionable wrongs, you can also look for a breach of a separate contractual provision to give you that independent actionable wrong, or breach of another duty such as a fiduciary obligation. So what now constitutes such a distinct and separate contractual provision in the employment law context? If you don't know the answer to that question, it doesn't make you a bad person. We're just developing the law in this area. A good example is a case called Marshall out of the Ontario Court of Appeal. And in Marshall, there was a claim for punitive damages, and one of the factors that the plaintiff's counsel relied upon in Marshall was the fact that the company had failed to pay some $80,000 in commissions. They'd been outstanding for some period of time, and by the time the employer got to the dismissal, those commissions remained outstanding, weren't paid, and indeed weren't paid right up to the time of trial. So plaintiff's counsel alleged that there was a specific contractual term to pay these commissions. They hadn't been paid, therefore there was a breach of contract, and as a result of this breach of contract, this constituted an independent, actionable wrong and could provide the basis for the court to award punitive damages. Court of Appeal disagreed. Court of Appeal said that, in fact, the failure to pay the commissions formed part of the overall claim relating to wrongful dismissal and the failure to provide the reasonable notice, and that in that particular case, compensatory damages were sufficient. So the court simply awarded the $80,000 in commissions that was outstanding. Now, Marshall, it seems, the Court of Appeal in Marshall actually predated the Witten case in the Supreme Court of Canada by approximately a month. And I think if the Court of Appeal had had the benefit of the Witten decision dealing with the insurance context, I suspect the answer may well have been different. It just doesn't make sense to me that an employer who acknowledges at trial, in this particular case, that they owed the $80,000, and they hadn't paid the $80,000, and there was no good reason why they hadn't paid the $80,000. It seems to me that that should be viewed as an independent breach and should easily give rise to punitive damages to express the court's displeasure with an employer coming forward with no apparent explanation for paying monies that are owing. So how far can we take breaches of contractual provisions in order to be able to found an independent actionable wrong? Look at statute for a moment. Think about the Employment Standards Act. Think about the Employment Insurance Act, the Occupational Health and Safety Act, the Human Rights Code. Surely there's an argument that every employment contract has an implied term that it'll be subject to applicable law. So what happens when an employer breaches any one of these statutes? Can it be argued that the employer is at the same time breaching an implied term in the contract, and through that breach, creating an independent actionable wrong giving rise to punitive damages? Barry tells me my broker's on the line. Thank you, Barry. What I'd like to do is maybe summarize for you in terms of pleadings, if I may. We've got the background in terms of Wallace now and the recent dialogue and debate about contractual terms and what to do with them. And the question now comes up as to how to actually plead this at the end of the day. It's not clear when the conduct that you have in a particular employment law case is going to give rise merely to a Wallace extension of the notice period, and when that conduct might give rise to the independent actionable wrong and in turn open the door to punitive damages or damages for mental distress. And given the uncertainty in that regard, I think the best advice that I can give in terms of pleading is that you may want to consider pleading in the alternative. And what I'd suggest in that regard is that you outline, for example, if you believe there are several breaches of contract, whether they be implied terms or express terms, that you plead all of those breaches, that you plead them as independent actionable wrongs, that you then open the door to the punitive damages and the mental distress damages. And you highlight that up front. Then I think you take that same conduct and you plead in the alternative that if the conduct does not get you to independent actionable wrong, that at the very minimum it gets you into an extension of the notice period based on Wallace. So that, I think, in a nutshell, is probably the best way to address the question of pleading. That way I think you keep the door open on all of these arguments. And obviously, as the common law develops, you want to be in a position at trial someday to be able to make whatever arguments are available on either front. In closing, just before I turn over to my colleagues, I just note for you the sort of practical side to wrongful dismissal litigation, and hearkening back to what Mr. Justice Echlin was saying about pleadings and how, in his experience, he generally didn't spend a lot of time challenging pleadings. My experience is, and I think most of us in this room would share it, is that probably 98% of this litigation never sees the light of day in a courtroom. And given that reality at the end of the day, I think Mr. Justice Ecklin's advice is well taken in terms of not jumping too quickly to get yourselves involved in pleadings motions, because number one, they're very likely, these cases very likely to settle, and number two, if it doesn't look good to you as a reasonable pleading, all you're probably doing with a motion to strike is educating the other side on how to properly plead it and then present evidence to go with it. Thank you. Comments from the defense?
I'm not defense, I'm plaintiff. Well, I'm going to be speaking just to the point that George ended on, because I found that my colleagues' papers were so, on the plaintiff's side, were so extensive on these hot topics that there wasn't much to add from the defense perspective. So I changed my topic somewhat. And for those of you who aren't happy, you'll be able to get a partial credit, I guess. And we'll speak to the issue of the importance of particulars and in what circumstances you might want to consider a motion to strike. I can reserve the comments to that time, I think.
I'm going to talk about some of the other independent actionable wrongs other than the ones that George mentioned. And I think it's fair to say that some of these claims are becoming more popular. That the gentleman's comment earlier that he had 3 statements of claims sitting on his desk with all kinds of other actionable wrongs listed is pretty common. My view is that you can summarize most of them down to "my boss is a jerk," because most of them seem to derive from situations of bullying or harassment in the workplace. And so what we're doing is trying to find categories to slot all of these things into, depending on the particular factual situation involved. And so what I did in my paper was give you a case study of a typical fact scenario. And it might seem extreme, but unfortunately, I don't think it is. I get tons of calls from people saying, "Oh yeah, my boss likes to say in front of other people, you're stupid, you're incompetent." One employer told the manager, "You should really not be nice to people. This is not how you run a business. We need to be mean." And their view of a performance evaluation was that it was secret. So you didn't actually present the performance evaluation to employees. You put it in their file to be used later when you try to terminate them. So this is the context in which I think a lot of these cases are arising. And so you'll see that throughout the paper where these cases come up. Now, the difficulty, of course, is because of Wallace, we need to separate these things from the manner of dismissal. When is it going to be considered just part of the manner of dismissal, and when is it going to be seen as something separate? So if I'm getting jerked around throughout my employment the whole time, and then I'm ultimately terminated, whether it's for cause or not, can I separate out that bullying, that egregious conduct, and say that it's a separate breach of contract? And that's where the Whiten case is very helpful. Although it was an insurance case, it did talk about the duty of good faith within the term of an insurance contract. And I think that that can be used within an employment law context to say that there is, in fact, a duty of good faith during the course of employment, not just in the manner of dismissal. And there are a number of cases on this which are primarily constructive dismissal cases, and I've reviewed them in my paper. One was Paytich and the Clark Institute of Psychiatry. And that was where Dr. Paytich suddenly had a new supervisor. And we see all kinds of cases like that. Everything's rolling along nicely, new supervisor comes in, and things all go to hell. And that's what happened with Dr. Paytich. And his new supervisor was this Dr. Hucker. And he had it out for Dr. Paytich right from the beginning and really mistreated him and made all kinds of allegations about his competence. And Dr. Paytich tried to get things resolved internally, filed a grievance, and he didn't get anywhere. So he increasingly became angry and filed some inappropriate memos, making a lot of accusations about some of the members of management at the Clark. Now, of course, all of this is interesting given that it's the Clark Institute of Psychiatry and they can't figure it out. But anyway, he files these memos and they're awful, and management says, "You have to withdraw those memos," and he says, "Oh, I'm not withdrawing those memos." And eventually they fire him for cause for not having withdrawn them. Now, the judge would not enter into the record any of what was in those memos, which makes me really want to read them because they must have been really bad. But the judge said it was so sensitive that he wasn't going to release them. But at trial, the judge said that supervisory staff owe a duty to those working under their authority to treat them fairly and to not subject them to individual harassment that renders competent performance of their work impossible. And this case was upheld by the Court of Appeal. And what they said was that Dr. Paytich could have considered himself to have been constructively dismissed months before they eventually terminated him. So they weren't going to let the Clark rely on the fact that he distributed those memos as being just cause, because essentially they drove him to it. The Lloyd and Imperial Parking case has been one that's been followed in Ontario as well, and it's an Alberta Court of Queen's Bench case that found that it's a fundamental implied term of any employment relationship that the employer will treat the employee with civility, decency, respect, and dignity. Now, that was also a constructive dismissal case, but I have pled that in plaintiff actions where I've said that it is an implied term of the employment contract, so it's a contractual term, to treat the employee with civility, decency, respect, and dignity, and the breach of that, outside of the dismissal, is then a separate breach of contract. So that is one where some of the harassment and bullying issues can be brought up in a separate manner other than just the duty to pay wrongful dismissal damages. Some of the other ones that are in there I'm not going to spend a lot of time on, but one is intimidation. So that is where there is a threat to commit an illegal act. That's another one that could be put in there. Defamation is one that's quite intriguing and can happen quite often. For example, where the person is saying you're stupid and incompetent. One I had, the employee was told you could get hit by a bus and I could walk out to the street and just like that I'd have somebody to replace you because you're worthless. Very nice. That's really going to get someone to be productive. But anyway, if that's just said to the individual, then it's not defamation. It has to be said with others present, which is often the case. It's often their colleagues. Sometimes it's someone who's in a supervisory position and their manager says it in front of that person's direct reports, which reduces their esteem and respect held by the employees. So again, defamation is a nice one to bring in. Unfortunately, some of the cases on defamation are pre-Wallace, so it's interesting to see what will happen because of Wallace. But one of them was Tremblay and Goddard. And in Tremblay, the individual was working in a foster home. And she did some things that were not appropriate in terms of the care of the child. And so they terminated her employment. And the employer was statutorily bound to file a serious occurrence report with the Ministry of Community and Social Services. And when they filed that report, it just said there was rough treatment of the child. On many occasions, she applied Julie's helmet with force, and on one occasion placed Julie in a cool bath. Then they gave her a letter of dismissal, which was a lot stronger and said that she applied the helmet with excessive force, placed the child in a cold water bath as opposed to a cool bath, and unacceptable child management techniques. And what the court said in that situation was the serious occurrence report was protected by qualified privilege, which meant the employer had a duty to produce that document and therefore was protected from a claim of defamation for having said what it did. But that letter of dismissal was an entirely different story. There was no obligation to send that letter to the ministry, which in fact the employer had. So by publishing it to the ministry and making those comments, which the court found to be untrue, that then constituted defamation. The troubling aspect of this, though, is that because it's pre-Wallace, I think if it were decided today, you would see that as a Wallace kind of claim, because it was in the manner of dismissal. It was at the time of dismissal that this letter was distributed to the Ministry of Community and Social Services. So I think that I would take that one with a bit of a grain of salt. Loss of reputation is also something that can be claimed, and that would be probably something that was maybe short of defamation, but certainly the person's reputation is called into question. So that could be pled as well, as long as it is pled appropriately. Nervous shock is one that was referred to in George Vassos' paper, mental distress claims. And this is something also to bear in mind. In a number of the cases, the courts have said these other separately enumerated claims are subsumed within a mental distress claim. So you'll need to make sure you've got it separated to the extent possible so that it doesn't all get rolled under a mental distress claim. But there are occasions when employees will have a claim without actually having suffered from a mental distress or emotional distress. They might not have any kind of psychological damage. And that's, for example, defamation. You don't have to show psychological harm. You simply have to show that there was the defamatory comments. But the nervous shock cases do require a visible and provable illness. So it's not worth advancing those claims unless you're prepared to get an expert report proving that the individual suffered some kind of physical or mental disability as a result of the behavior of the perpetrator. And one of the elements of intentional infliction of nervous shock is outrageous conduct. And that's a very high test, but I can tell you that our perception of what is and is not outrageous has changed over the years. And comments or conduct that we would slough off in the past, we now see as very high-handed sexual harassment, for example. So our notions have changed, and I think the likelihood of succeeding on a nervous shock claim has correspondingly increased. And the last one I want to talk about quickly is the civil action for sexual harassment. Now, Nancy in her paper talks about a case that was recently decided by Mr. Justice Echlin, in which an individual had brought both a sexual harassment complaint and a wrongful dismissal complaint, including in it components of the sexual harassment fact situation. And it was decided that I think it was the human rights complaint should be stayed, right?
That's right.
Yes, because that was the one that was filed second. But there are cases out there that have suggested that regardless of whether an employee has filed a human rights complaint, you can bring a claim for sexual harassment or discrimination or other forms of harassment, a separate civil action, even though we have it under statute. It's just that you'd probably need to plead it slightly differently. You wouldn't be pleading it as a breach of the Ontario Human Rights Code, but you might be calling it negligent or intentional infliction of harm. So you'd want to plead it slightly differently so that you don't have it struck out. Because in Beduria, that was a Supreme Court of Canada case, they said you cannot bring a statutory claim under the Ontario Human Rights Code. But you can bring a statutory claim under the Discriminatory Business Practices Act, a little piece of legislation that nobody knows about, and I didn't know about until someone from George Vassos' office sent it to me. But anyway,
Not me.
Yeah, he's not going to take credit. It was Monty Verlin. But it's a fabulous little piece of legislation that says right in it that there is the right to sue if an employer, if a corporation has breached the Discriminatory Practices Act. Now, I've given you a laundry list. There are other ones that I haven't included. For example, intentional interference with economic relations or assault or battery. Those are ones that I've had in several cases. So if the manager's standing there spitting in the person's face because they're yelling so loud, you might be able to allege assault. And one final thing on the pleading side is to consider whether or not to sue the individual bully personally. There are times when that can be very effective. For example, the bully or perpetrator could be an owner of the company and they're just trying to hide behind the veil of the corporation. And when you list them personally, it sometimes causes them to react more quickly and try and settle it more quickly. But this flip side can also happen. It can also cause them to dig in their heels and say, screw you, I am not settling this because my reputation is at stake. Okay, you have no reputation. But anyway, that is something that you definitely want to consider. And it's always difficult as a lawyer to make that call. You need to talk to your client as much as possible about what the personal defendant is like and how they are likely to react to that kind of a claim. But it's often a very valuable tool in presenting your claim. So that's the laundry list of other types of torts that you could sue for, but obviously you need to particularize them carefully so that they don't get wiped out. But it can be very interesting, and I encourage you to be creative in looking at the particular fact situation to try and deal with the situation at hand. Thank you.
As I've already warned you, I've changed my topic slightly, and my advice is that if you follow the advice of the counsel that's speaking on the plaintiff's perspective in pleading some of these hot topics, you will leave very little for defense counsel to do other than simply file a statement of defense. And so I went looking for other recent developments and considered some other topics, particularly from the defense perspective, that I might speak to. And I have to say, especially with a practice that's I'm more of a generalist, so employment is just one aspect of my practice, I was quite surprised to see the number of cases dealing with motions. And I guess Justice Echlin has explained the volume that they see still in the courts. But certainly my experience has been that motions for particulars, motions to strike, are fairly rare. But certainly in the employment law context, based on some recent case law, there seems to be certainly a considerable number of them. And I sort of reflected as to why that might be. And I think there are a number of reasons. I think, first of all, and then I'll explore some of these cases, the courts seem to be quite willing to read in a lot into a statement of claim based on what the case law has established. So I think that's the first thing. The other thing is that with the developments in the Wallace case, claims for bad faith and punitive damages and aggravated damages are becoming more common. And of course now with the need to plead a separate actionable tort or wrong, you've got to become creative and adopt some of the kinds of claims that Lauren has just spoken to try to, from the plaintiff's perspective, enhance the award for your client. And I think all of that does bring us to a greater focus on the statement of claim, and I think from the defense perspective, that you at least should be considering some of the steps that I want to speak to before you simply file the statement of defense. The first question, I think, and I think having reviewed all of these cases and thought about what I wanted to speak to today, this is probably the most important, is considering whether or not you need to make a demand for particulars. And I'm not suggesting that you do that in every case. I'm very strongly of the view that if the demand for particulars is only going to improve the quality of the plaintiff's statement of claim, then obviously that's not something that you want to do. The trial judge is going to see that statement of claim in its original form and draw certain conclusions, and you're already ahead of the game if you've done a proper defense. But you have to consider some of the downfalls if you don't make a demand, and also whether you should be considering a motion to strike. And so I want to consider, first of all, the pleadings perspective and particulars. If there's a real concern about being taken by surprise at trial, then I think there's no question that you ought to make a motion for particulars. And I refer to a couple of cases in the paper, the Barracuda case from the Nova Scotia Court of Appeal, where the appellate employer asserted on the appeal that the pleadings didn't support a consideration of the manner of dismissal. And the court conceded that the pleadings were not unduly informative, but concluded nevertheless that they did frame a claim for reasonable notice for breach of contract. And by a simple claim, I think the statement of claim alleged that the employee was terminated without just cause, without notice, and that the severance he was offered was totally inadequate considering all of the circumstances. That was it. And based on that, the court considered not only the usual factors in determining reasonable notice in the Bartle and Globe of Mail case, but also included the manner of dismissal as explained in Wallace. So whether or not the employer was really taken by surprise or not, but is unclear. But certainly the fact that they were suddenly facing a Wallace claim at trial, I think would not something you want to be unsure about when you reach the trial stage. The court referred to a couple of cases, and of course we've had this flux now with the Wallace case going to the Supreme Court of Canada, but both Squires and Noseworthy were cases where between the trial decision and the appeal decision, the courts on appeal applied the Wallace principles and in a sense allowed for Wallace claims which have clearly not been pleaded or even argued. And based on that, decided that it was not unfair and upheld the trial decision, awarding a Wallace bump, if you will. And so in a case like that, looking back on it, I think it would have been prudent for employers' counsel to make a demand as to what was meant by all of the circumstances, and I might have been in a better position then to withstand that sort of argument on appeal. The Prinzo case was also similar. On appeal, the employer submitted that the plaintiff did not plead a separate actionable wrong. There, what the employer did, though, is anticipated it in a sense, pleaded to an imperfect claim and denied that there was any willful infliction of mental distress, and of course gave it away that really knew what the claim was all about, because that, of course, is the key element in a claim for mental distress. And so the court found that the employer was not taken by surprise in that case. And again, a better way of dealing with that might have been a demand for particulars. Now, the advantage of this, I think, was brought home to me when I read the Antonacci and Great Atlantic case. It's a decision of our Court of Appeal, a recent one, and the court there came to a different conclusion than the other two cases I've just referenced, and found that there was a real surprise for the defendant, because it was only upon reading the trial judge's reasons for decision that the basis for a claim and an award of aggravated damages became apparent. And in that case, the trial judge relied on a letter sent by the employer to the Workers' Compensation Board advising that the plaintiff had been dismissed for cause as a basis for a claim for an award of aggravated or punitive damages. The letter had not been referred to in the pleadings, and to make matters worse, there had been a demand for particulars and it hadn't been referred to in the response. And that, I think, of course, was key in the court's decision. Of Court of Appeal found that the conduct in that letter, the writing of that letter, fell outside the scope of the pleadings as particularized, and that to give effect to the finding of the trial judge and the consequent award of aggravated damages would defeat the whole purpose of particulars. So I think that case brings home the importance of demanding particulars in cases where bad faith is claimed, punitive damages, mental distress, sexual harassment, any case where you want to really be careful to nail down all of the individual items of misconduct that's being alleged against the employer. And if you have to resort to a motion, which is unusual, I think typically a demand for particulars will you'll get a proper response. But if you have to resort to a motion, I've referred to the Champagne case in my paper, a divisional court decision, which is the kind of case I like for putting in your factum, where you're really referring to a lot of fairly trite law and you want to do it concisely. It's got a good summary of the law with respect to particulars. It's also a good example of a case where particulars were ordered where there was a claim for damages for sexual harassment. The plaintiff on the motion filed an affidavit saying that the conduct was of a continuing nature and it would be impossible to give all the dates and times and places of the sexual harassment claim. And the divisional court found that the trial judge erred in ruling that the affidavit provided sufficient particulars and ordered that the plaintiff provide particulars, all of the allegations, I should have said motions, Judge, and also summarized the principles of law that apply, which of course is to prevent surprise at trial, most importantly, but also to limit the discoveries. Now, if you do have to resort to a motion for particulars, the one thing that you might want to consider is adding to your relief a motion to strike as well, even though you're not seriously looking to strike the claim permanently. There's a decision in the paper by Justice Malloy, where the Adam Smith case, where she found that to order particulars on a piecemeal basis was really not going to make for a very coherent pleading. And so she ordered that the offensive, well, actually she struck the pleading and ordered that it be repleaded with sufficient particulars. Now, from the defense side, that means you're facing a better pleading. On the other hand, it may be very difficult to defend something that's been particularized on a piecemeal basis. So you have to sort of weigh the pros and the cons. But certainly if there are serious deficiencies, it's wise to add that to your claim for relief. I'm going to be speaking separately about motions to strike, but there may come a time where you're considering whether or not there's a motion to strike on one of these novel causes of action that Lauren has spoken to. And if you think that there is some advantage to bringing first a demand for particulars and a motion for particulars, there's a case of Justice Pepples in the paper, the Haynes marketing case, which is important because she found that a demand, and in fact going so far as a motion for particulars, was not something that would preclude bringing a motion to strike later. And she allowed a motion to strike, notwithstanding that the defendants had already demanded particulars and had brought an earlier motion for those particulars. Now, turning to motions to strike, when you're looking to strike all or part of the statement of claim, if you're looking to try to strike a novel cause of action on the basis that the pleading as a whole or a significant portion of the pleading does not disclose a reasonable cause of action. The Clitheroe case in the paper summarizes the current law on that, and you want to ensure before you bring a motion of that nature that you're going to have some reasonable prospect of success on having the pleading struck without leave to amend. Because otherwise you're spending a lot of time and money, and at the end of the day, the most common order in those circumstances is that the pleading is struck, but with leave to amend. And so then all you really have accomplished is a better pleading, and you've enhanced the plaintiff's position. Now, in the Clitheroe case, there was some mixed success on that, and if you think that the pleading, if you think that there's no way the plaintiff can properly plead the claim, that there is no basis in law, then that's the time to bring that motion. But the courts have said it's got to be plain and obvious that there is no claim. The allegations in the statement of claim, of course, are taken as being capable of being proven. The claim is read generously. And most importantly, in this area, the fact that the law is not settled or that the claim is a novel one does not mean that the claim is struck. If there's any chance, I mean, there is still a threshold, but if there's any chance of success at trial, then the claim will be allowed to proceed to trial. So unless you can find a case where it's already been decided that there is no such cause of action, or you can find, if you can establish that the elements of that cause of action could not be properly pleaded in the case, then don't bring that kind of motion to strike. There are, however, some examples in the paper of times when you might, as an employer's counsel, want to move to strike aspects of the pleading that are truly embarrassing to the employer, are going to cause you some grief on discovery and if the case goes to trial. And in the, I'm not sure if I can say it, the Ganaz-Zagram case, it's a decision of Justice Summers, referred to in the paper. The plaintiff was alleging that she was denied advancement within the company because of her race and color, and she was pleading, made reference in her pleadings to the discriminatory practices of the company, and alleged systemic discrimination against other employees as part of her claim. Now, in that case, Justice Summers dismissed those aspects of the statement of claim, and those portions were struck, and that, of course, would be without leave to amend. He found that those were not relevant, and so that would have been a worthwhile motion to bring, because then that all of that evidence would not be led at trial, which would no doubt cause some grief to the employer if those sorts of discriminatory practices were prevalent. Different conclusion was reached by the divisional court in the Hodgson case. The plaintiff was pleaded it better, pleaded that there was an ongoing corporate strategy to get rid of unwanted employees, made reference in the pleadings to the kind of conduct that Lauren described of insulting voicemail greetings, etc. So obviously fairly inflammatory pleadings from the plaintiff's side. But the divisional court found that that pleading was relevant to the claim for punitive damages, and referred to Rule 2506 sub 8, which talks about pleading fraud and malice and those sorts of things and the need to have full particulars. So from the plaintiff's side, if you want to try to plead other aspects, the way the employer deals with the other employees, or corporate strategy, if you will, then obviously you've got to try to make it relevant to some aspect of your claim, and which would preclude then that kind of motion from the employer's side. The motions to stay is another issue that I dealt with, and Lawrence touched on the McKelvey and Publicis case, and I think I misspoke too quickly, Lauren. It was actually one day before the action was launched that the human rights complaint was brought, and so Justice Echlin decided that because it was brought the day before, that the civil action would be stayed. And it's a good review of the case law, which does appear to be mixed. Although I think most of the differences in the case law can be reconciled on the basis as to whether or not there will be prejudice. Because clearly, if you stay a civil action, there's going to be prejudice to the plaintiff because of there will be delay to the plaintiff. The issue is then whether or not there's prejudice. There is, for example, the decision of Justice Lax that was referred to in Justice Echlin's decision, where the plaintiff was HIV positive. So obviously there was prejudice. But in the case that he faced, there was no prejudice. He left open the question as to whether or not he could stay the human rights complaint, decided instead to stay the civil action. I'm told my time is up as well, so I'll just finish on the issue of pleading just cause. I considered in the paper whether or not it's still ever possible to plead just cause and fail and not be faced with a Wallace claim. And I think logically it should be possible. And in fact, there was one case, it's the simplified rules case, but a decision of Justice Lowe that's referred to in the paper, where she made an express finding that notwithstanding the failure to establish just cause, there wasn't evidence of bad faith or harsh treatment, so she refused to impose a Wallace factor. So I think if you're going to plead just cause, and I know MacKillop will speak to that issue this afternoon, from the pleadings perspective, you're going to want to, number one, make sure you thoroughly investigate your case first so that you don't end up alleging particulars that you ultimately can't prove. There is no factual foundation to. And secondly, be very careful with your language. Don't bump it up a notch. Be very fair, avoid inflammatory language, state the principles clearly so that obviously you don't have a problem alleging and raising all the issues at trial. But be careful how you deal with it, and I think then, subject of course to all of the other evidence falling into place, you should be able to still, and I think this will really apply in the near cause cases that are it's no longer possible to find near cause, but in those kinds of cases where you want to obviously still pursue whether or not there is cause for termination, plead it, but be careful and make sure you have the facts and support. I also would draw your attention to pleading offers to settle. I think that will, where it's possible, will be important in cases where claims for bad faith are being made, and it's something that you might not otherwise consider because typically offers to settle, of course, are not pleaded. That's it. My time's up.
As a result of what you've heard from George with respect to Wallace and what you've heard from Lauren with respect to the potential damages if plaintiffs can prove independent actionable wrongs, my view as a defense lawyer is you do not want to put yourself in the situation where your client is going to be assessed damages either on the basis of Wallace and the bump up or in the case of damages following an independent actionable wrong. So I think that defendants, employers, should take advantage of the control that they have to control their destiny, if you will. Employers, before they terminate employees, are in a way analogous to a prize fighter, the champion prize fighter who can decide when he's going to fight again, where he's going to fight again, and who his opponent is going to be. So take advantage, if you're acting regularly for defendants, of the fact that you have this long relationship, presumably, and that you've trained them to come to you before they're about to terminate someone's employment. And then try to create the evidence that's either going to blunt a plaintiff's attempts to claim a Wallace bump up or claim an independent actionable wrong, or which will allow you to plead evidence of good faith and evidence that you dealt fairly with the plaintiff. Let me suggest that there's 9 areas that you might want to try and create that evidence in. The first is timing. You control, as an employer, the timing of the termination. So one of the constant claims that support a Wallace-type claim is, well, you terminated my employment just before my birthday, or just after my birthday, or just before my wedding anniversary, or just after my wedding anniversary, or just before I went on vacation, or just after I went on vacation. My view is it's almost impossible to avoid a timing issue, but take into consideration, to the extent possible, the timing of when you're going to terminate someone's employment. For example, I have this rule, it's my rule. I don't think it's a good idea to terminate anybody after December the 15th of any year. It's just a bad idea. Wait till January. The second is, and this is a somewhat novel idea, why not give an employee reasonable notice of the termination of that employee's termination? Give reasonable notice to the employee of the termination of the employee's employment. If you're looking for almost a gold standard way of avoiding a wrongful dismissal action, a bump up on the basis of Wallace, an independent actionable wrong, why not give the employee notice today of the termination of the employee's employment 6 months from now, 9 months from now, 12 months from now? Think about that. It's an option that's not considered nearly as often as it should be, and it's a very good way of reducing the risk. The third area, or third piece of evidence that you can create is by providing outplacement counseling unconditionally, EAP unconditionally, and make that part of the letter of termination. Again, you're creating evidence. So if evidence of bad faith can be pleaded so as to support the bump up, maybe evidence of good faith can be used not only to reduce the bump up or eliminate the bump up, but I'm waiting for the right case to argue that that should have the result of reducing the notice period. Think about that one. Fourth, I can hear the reaction from the plaintiff bar that aren't even up here. Fourth, why not make a virtue out of a necessity? pay the Employment Standards Act minimums. You do not want to be faced with the allegation that you didn't pay the Employment Standards Act minimums. So my philosophy is make a virtue out of a necessity. Be able to at least blunt the suggestion that you didn't pay the Employment Standards Act minimums that you should have. In fact, plead that you did. Make a with prejudice offer of settlement. This is something that Nancy mentioned in passing. If you're going to be faced with a claim for punitive damages or for damages for mental distress, or that you didn't act fairly or you didn't act in good faith, why not in the letter of termination include a with prejudice offer of settlement, or even one step further, make an unconditional payment? I'm not recommending that, but it's evidence that you can create as the employer that will reduce the risk of a Wallace bump up or an independent actionable wrong. Again, on the sixth piece of evidence, provide that letter of reference, not the name, rank, and serial number letter of reference, the letter of reference that's fair, reasonable, and objective. It takes away one leg in support of a Wallace-type argument, and it gives you another piece of evidence that you can rely on in support of your claim that you've acted in good faith. Seventh, strictly limit the number of people who know the reasons why someone's employment has been terminated. Employers all of the time fall into the trap of publicizing to far too broad an audience that someone has had their employment terminated. You're just asking for it. You're sticking your chin out. Avoid the temptation to try to justify what you've done. Simply keep the information as to the reasons why someone has been terminated to the most fewest number of people possible, so as to avoid the allegations of humiliation, embarrassment, and damages to the employee's reputation. We've talked about timing. We've also I want to talk about for a moment the idea of making sure that when you actually do carry out the decision to terminate, that you do so in a way that minimizes the risk of embarrassment and humiliation. So questions about when to do it. Do you do it on a Monday? Do you do it on a Friday? Do you do it on-site? Do you do it off-site? These are all things that you as an employer can control. And the ninth one is, again, in the spirit of making a virtue out of a necessity, don't do what so many employers do, and that is issue records of employment only after they've been asked 4 or 5 times by an employee for the record of employment, and they don't actually issue it for weeks and weeks and weeks. It's absolutely unnecessary. It exposes you to the Wallace bump up. If you actually do it and you do it in a timely way, then there's no reason why you can't point to that in your pleadings as evidence of good faith. We're running short of time. Let me just go on to a couple of other areas that I'd like to mention for a moment. I agree with Nancy that there's no reason why employers can't still allege just cause. I agree with all of the comments that she made. I think that many defense counsel are afraid to assert just cause now because of Wallace. And while they should be afraid to some extent, they shouldn't be so afraid that they don't do it in the appropriate case. I strongly believe that there's still room for the idea that you can plead cause, and if you don't think after your examinations for discovery have been completed that you're going to be able to assert it, that's probably the time to drop it. But don't stop pleading cause. Where you genuinely think there's a triable issue on that issue, I think you can still lose a case where you've pleaded just cause without getting awarded against you a Wallace bump up. Final comment. Many plaintiffs put the employer's conduct in issue under the Wallace heading. And on many occasions, I do just the opposite. I say, fine, let's look at the plaintiff's conduct. Is he or she lily white? And it's the rare case where they're lily white. So the plaintiff claims that the workplace is poisoned. It's a poisoned work environment. Well, what did he do or she do to make that workplace a poisoned work environment? Sometimes plaintiffs who live in glass houses should think twice before throwing stones, because often, if you look hard enough, there's evidence that not only were they a willing participant, they were often an instigator. Not always, but look for the evidence that will, in effect, deflect all of the blame from the employer. That was the employer and all of the people that Lauren described who have come to see her who created the poison work environment. Look to the plaintiff and see what evidence you can uncover as to whether the plaintiff contributed to that poison work environment as well.
Well, thank you very much to all of you. It's perfect timing. If we could all be back at 11 o'clock, we appreciate it. And thank you.
Was it trouble you with approaching questions? Sure. Sorry, you finished, sir? Okay, yeah. Are you almost in